So I was asked to provide a bit of an update about what is going on in Canada, and I can confidently say just about everything is going on in Canada, and it's largely in process. And so I'll be talking about some significant changes to our federal privacy law, currently known as PIPEDA, the Personal Information Protection Electronic Documents Act, which is proposed to be replaced with the Consumer Privacy Protection Act. And the bill that gives it effect also creates a personal information data protection tribunal in order to oversee data protection matters in Canada in a way. And they've bundled with it something called the Artificial Intelligence and Data Act, which I'll give a bit of an overview of, at least to the extent that anything is really known. Quebec is also is in the final stages of completely overhauling their private sector law for data protection in the private sector, with some significant changes that I'll talk about. Mentioned the renewal of Canada's GDPR adequacy and some question marks that have followed that. And we also have something called Bill C-63, which is the Online Harms Act, kind of similar to, but not quite the same as digital safety laws that have been implemented elsewhere. And I don't think I'll have time to dig into that in any great detail, but just to have that on your radar for any of your clients that operate particularly social media type service that might have users in Canada. It's going to create a significant regulatory burden that unfortunately I don't see as being particularly compatible with what's happening in Europe and elsewhere. But we'll start off with this Consumer Privacy Protection Act. So we've had a federal privacy law that regulates the private sector in Canada since 2001. That statute is PIPEDA. And there are provincial equivalents in British Columbia, Alberta, and Quebec. The Quebec one predates PIPEDA. The British Columbia and Alberta ones came into effect in 2004. We haven't seen a whole lot of changes to it in the intervening 24 years. It was updated with an update statute, essentially, that largely just added data breach notification. But it's kind of hobbled along using its 2001 model until 2019, when the government introduced Bill C-11 in order to replace PIPEDA with the Consumer Privacy Protection Act. The way our parliament works, that fell off the order paper and had to be reintroduced in 2022 in the form of Bill C-27 with some significant changes. It was tabled and it's currently still working its way through parliament. And what the timeline is, it's not that clear. But just some highlights. While it completely replaces the existing statute, PIPEDA, and there's some significant changes, it doesn't replace it all, or it doesn't kind of throw out the existing model. When talking to clients, I've essentially said it takes PIPEDA, existing PIPEDA, and turns it up to 11. That things that were already implemented best practices by diligent companies and organizations, like having a privacy management program, that's now going to be required. There are requirements for prescribed policies and particular forms and practices and procedures being documented that weren't required previously, but most diligent large organizations did that. All of this documentation has to be provided to the Privacy Commissioner on request. And there's the possibility of adhering to a code of practice if it's approved by our Privacy Commissioner of Canada. And I'm not sure how attractive that's going to be. The interesting thing is that most large companies in Canada and most large international companies that do business in Canada are relatively diligent and have everything well documented. But this statute applies, including to small and medium-sized businesses that perhaps haven't turned their mind to documenting, even if they had good practices, to documenting those practices. So there's going to be a significant kind of burden or obligation. I don't think we're going to see the same sort of scramble for privacy professionals that we saw in Europe in 2018, but we might see something similar to that. And any organization that does business inbound into Canada is going to need to think about these sorts of things. There are obligations with respect to, again, notice kind of the theme of documenting and having policies and things like that. That when it comes to the collection of personal information, it's still largely based on consent, and one has to record and document the purposes for which the organization is seeking consent. The bar for seeking valid consent is getting higher, but there are quite a few consent exceptions related to legitimate purposes and things like that. But again, unfortunately, it doesn't align very closely with, for example, legitimate processing in Europe. consent remains the main purpose or the main basis upon which personal information can be processed. If you want to use one of these consent exceptions, again, you have to document the rationale and document the kind of privacy risk analysis that goes along with it. Again, similar to Europe, but not sufficiently similar that you can say, oh, well, what you're doing in Europe or what an American company is doing for GDPR, well, they can just transplant that over to Canada. So there's enough of a delta between the two to create friction that's going to be uncomfortable for some organizations. There is some uncertainty related to its scope. So the existing PIPEDA applies to the collection, use, and disclosure of personal information in the course of commercial activity, except where it's subject to a substantially similar provincial law. And so commercial activity generally, then the basis for jurisdiction, if it reaches into Canada or deals with Canadian consumers, that's probably enough for Canadian privacy law to apply to that collection, use, or disclosure. But in the CPPA, they've also added on, so it applies to the collection, use, and disclosure of personal information collected in the course of commercial activity, including for greater certainty, information that's collected, used, or disclosed, or transferred interprovincially or internationally. And so some view that as extending the scope so that even if it's not engaged in commercial activity, the statute is going to apply to it. If that's the case, I'm generally not in favor of expanding laws willy-nilly, but we have an actual gap. And I'm going to talk about our adequacy finding in a bit. PIPEDA does not apply to employee personal information unless that employee is employed with a Canadian regulated federal work undertaking your business, which means that there is in fact an existing gap for employee personal data that's transferred, let's say, from Europe into Canada. That falls outside the adequacy because it's not subject to PIPEDA. But this provision could do that. And I'm hoping they're going to strengthen that and clarify that so that, if data comes from Europe into Canada for processing or a disclosure, that will clearly be within the adequacy finding, and the Canadian law will apply to that to make sure that there is substantial protection to it. I think our commissioner's kind of taken the view in the past that they have jurisdiction over anything that happens internationally, but we didn't have that language in the statute that gave that sort of certainty. And the existing language in Bill C-27 CPPA, I would like to see it even more clear so that we know exactly what it's intended to apply to. But it's something of particular interest, I think, for people on this call who may have a connection to or have clients who have a connection to Canada and understanding kind of really what is their legal framework. As with some other jurisdictions, there's a greater emphasis on data mobility. There isn't a strict data portability blanket provision. What they've done, so open banking has been a topic of interest in Canada, and I think we're behind the times when it comes to that. So it's looking at having a regulatory framework in which approved data portability frameworks and rules can be approved by whichever regulator. And through that, an individual will have a right to have their data transferred from one organization to another, either all of it or part of it. There's a limited right to erasure, which is very similar to the existing. So because consent is the basis for the collection, use, and disclosure of personal information under PIPEDA, and it also says you can withdraw consent, that implies a right to erasure. Well, this is making it a little bit more clear that an individual can say, please erase my data, and the organization is going to have to do that. But our statute, interestingly, doesn't include anything like a right to be forgotten, as is in Europe and has been introduced in Quebec. And that whether that right exists under PIPEDA is currently being litigated. It's gone through the Federal Court of Canada, and it's likely to go back to the Federal Court of Canada when the Privacy Commissioner issues a finding eventually. And just for transparency, I'm co-counsel for Google on that particular case, but we'll see how that's going to play out. But the legislators didn't choose to introduce a specific right to be forgotten and protection of reputation in this new bill. There's also an obligation with respect to algorithmic transparency, so a requirement to be transparent about the use of algorithms, and in some instances, human review or second guessing of those sorts of things. There's some overlap from that in the Artificial Intelligence and Data Act. Not necessarily contradictory, but as I'll talk about ADA, the Artificial Intelligence and Data Act, we'll see that the two weren't designed to work hand in glove. I think they came out of different different offices and within our federal bureaucracy without a whole lot of coordination. Probably the most significant change overall is that the privacy commissioner, who currently is simply able to issue reports of findings and make recommendations, and is then able to take an organization to court to require them to change their practices. The privacy commissioner is being given significant new enforcement powers. And so the enforcement powers are going to be in investigations by the privacy commissioner, then inquiries also by the privacy commissioner's office, and the possibility of the privacy commissioner making orders, interim orders or permanent orders. And then we have this new tribunal that's being created, which is interesting. It's not a model that we've had before. As I said before, the privacy commissioner could take the organization to the federal court, and the federal court could impose remedies. This interposes a new tribunal. I'm not sure it's going to streamline things, and it may in fact create a new bureaucracy. So the tribunal has to have a minimum of 5 members, or a minimum of 3 members, but at the very least 3 members have to have expertise in privacy law. The tribunal will review the privacy commissioner's findings and orders with a relatively high standard, and they do have specialized expertise. And they're the ones who are going to implement financial penalties of kind of GDPR sort of levels. So non-compliance with the legislation can result in financial penalties, which currently don't exist in Canadian privacy law. There's also quasi-criminal financial penalties that are of kind of GDPR level magnitude. And there is, in fact, a private right of action for individuals who have been affected by a non-compliance. So after a complaint has gone through the process, any affected individual is then able to go to the courts in order to seek a remedy related to that. And it's extremely open-ended. It doesn't have to be the person who made the complaint. It's just anybody affected by it. And there's the possibility of taking that lawsuit to the Federal Court of Canada or to any provincial court. So I'm afraid that we're likely to see significant redundant overlapping lawsuits that are going to take place within across all of our provinces and in the federal jurisdiction, which I think will be a significant cost of doing business. A number of people have pointed out to the parliamentary committee that's reviewing this is that that overlap and redundancy is particularly with an already overburdened court system is probably a big mistake that they're making. And when they introduced Bill C-27, to everybody's surprise, it also included something called the Artificial Intelligence and Data Act. And so this wasn't expected. As I said, it was a big surprise, and it arrived with no consultation whatsoever with the technology community in Canada or even the AI community or otherwise. It was just a big surprise. And if you look at it, you see that it doesn't share the same regulatory framework as the CPPA. So it's not overseen by an independent regulator like our privacy commissioner. It doesn't go through the same tribunal, the Personal Information Data Protection Tribunal. It goes through a completely other mechanism. And in terms of telling you what it does, it's very difficult for me to tell you what it does because it's still a bill and so much is left to the regulations. So the core of it is a concept of a high impact system. But we don't know what a high impact system is because the criteria is going to be determined by regulations, and we don't have those draft regulations. All we have are some pronouncements by the minister responsible for the bill saying that, for example, recommendation engines on Netflix and YouTube are a high impact system. That kind of helping you figure out what airline flight is best for you is a high impact system. So there seems to be a significant disconnect between the analogous concept in Europe, for example, again, using similar conceptual terminology, but distance from, in fact, what the substance is, that I think ultimately will create some friction and make things difficult. The focus is on assessment of risk and mitigation of the risk, and then transparency related to the risk of these particular systems. And these include, again, significant offenses and penalties. So our government has gone from the ombudsman model with findings and wagging your finger at organizations to significantly punitive models that need to be taken into account. So where does this stand now? So all of this is currently before the House of Commons Standing Committee on Industry and Technology. Everything is on pause for the summer. The Parliament has recessed. Once it finishes that process, it's then going to go to the Senate. There's a lot of pressure to take ADA, the Artificial Intelligence and Data Act, off of the rest of the statute. in part because I think everybody has recognized the privacy piece, while it might have some issues, and there's something in there for everybody to love and something in there for everybody to complain about. There's a consensus that, the time has come, that this is a reasonable compromise and it should be passed. But there's still a lot of debate and discussion about ADA, and if they could take them apart, they could pass the privacy piece and maybe send ADA back to the drawing board. I think overall it's likely to take years to come into effect if it's passed. And the reason why I say that is it really depends on the existence of this tribunal. And in order to stand up this tribunal, they're going to have to recruit at least 3 commissioners. They're going to have to hire a staff. They're going to have to get office space. They're going to have to do all these sorts of things. And having seen firsthand what happened when it came to a new regulator for example, patent agents and trademark agents, that's a multi-year process. So I expect we're going to have a bit of a pretty long runway in order to get ourselves ready for this. So also in front of Parliament, and still making its way through, is a statute called the Critical Cyber Systems Protection Act. And so it focuses on, so in Canada, jurisdiction over a lot of things is divided between the federal government and provincial governments. And the line is sometimes difficult to see, but sometimes it's really quite clear. So the federal government is introducing critical systems protection legislation for areas within its exclusive jurisdiction. And that includes telecommunications service providers, international interprovincial pipeline and power line systems, nuclear energy systems, transportation systems that are interprovincial or international, banking systems, and clearing and settlement systems. Now, more can potentially be added. And the thing that is of particular interest is that all of this goes down those organizations' supply chains. And the framework is, it makes some sense. It requires every organization that's a regulated organization to identify and manage all of their cybersecurity risks. They have to protect their critical systems from those risks and from being compromised. They have to detect any incidents that are happening or that have the potential to affect their systems. They have to minimize the impact of any incident that happens, and then the open-ended do anything that is prescribed by the regulations. So again, in true Canadian style, a lot of significant stuff is left to the regulations that we don't know exactly what it looks like. So every affected organization has to have a documented security program. They have to file it with their regulator, and different sectors have different regulators, depending on, for banking has the Office of the Superintendent of Financial Institutions, others have different regulators. So this program has to be regularly reviewed and updated, and you have to file updates. If there's a significant change, for example, to a contractor or your network topology or anything else like that, that has to be updated in the program and has to be provided to the regulator. There is involvement by the Communications Security Establishment of Canada, which is like the National Security Agency in the United States, or GCHQ in the UK. It's the organization, one part of it spies on people, spies on telecommunications, particularly international telecommunications. The second part is responsible, generally up until this point, for safeguarding and security of Canadian government IT infrastructure. And so they are now going to have a role in the private sector that they haven't had before. There's a requirement to immediately report any incidents to the Communications Security Establishment of Canada and notification to the designated regulator for those, which again makes some sense. It makes sense to have somebody to have visibility across all the different operators with respect to any, for example, cyber campaigns against those critical systems. So reporting seems to make sense in this context. But the one thing that's gotten a fair amount of attention are cybersecurity directions. And these are issued by the by the Governing Council, which is essentially Canada's cabinet. And these orders can be directed to specific designated operators or even classes of them. And these orders are generally not published and they're not public, and they may in fact be secret. So an organization is prohibited from disclosing. And I think the example that many have used is, we've seen it in the United States, we've seen it in other places. There is some controversy, for example, about our telecommunication system and our internet switches being controlled, for example, using hardware from China, Huawei in particular. And so, for example, the government can order anybody in the telecommunication space and the banking space to remove all Huawei hardware from their systems. And again, but they can do it secretly. And there are also some concerns that if the government tells everybody to implement a particular system, if that system has any vulnerabilities, then everybody who's on the receiving end of one of those orders is going to have that vulnerability built in. So there is some controversy about this, and it'll be interesting to see what further comments come before the parliamentary committees when they resume in the fall. It's about supervising the good guys and not investigating the bad guys. These regulators have very significant search powers going into an organization, taking a look at their systems and taking a look at all the things that they're doing. They can issue compliance orders and notices of non-compliance, and those can result in significant penalties, up to $1 million in the case of an individual. Although it's hard to see an individual being a critical cybersecurity component of the telecommunication sector, but in any event, $15 million in any other case, so for an organization or for a business. There are due diligence and common law defenses available, but those are relatively limited. If you're ordered specifically to do something and you don't do that thing, your due diligence defense isn't going to be very helpful. There's liability for officers or directors, which grabs the attention of these regulated entities and puts a significant onus of compliance and due diligence on those officers and directors of those organizations. And the penalties are compounded, essentially. If you're out of compliance for 5 days, you've offended 5 times. And that can result in 5 times the penalties. And so it will be interesting to see what the appetite will be of the regulator and of the minister's department when it comes to implementing these sorts of penalties. I've heard some say, well, this is going to be a disincentive for some non-Canadian companies to do business with Canadian companies in those particular regulated spaces. But we'll have to see how this all plays out. I mentioned, and I'm only going to touch on this briefly, Canada's GDPR adequacy was the subject of additional attention. So our PIPEDA was initially found to be adequate for the European Data Protection Directive on the 20th of January, 2001. And certainly the existence of the European Data Protection Directive and the requirement or the desire to come up with an adequate framework was a significant impetus in Canada in the late 1990s, early 2000s to come up with our Personal Information Protection and Electronic Documents Act. And there's always been a fair amount of pressure, which was really amped up, particularly in 2018 when the GDPR came into effect, of a concern that we are lagging behind. So Europe takes 2 steps forward. Canada is still at a 2001 posture. I think our 2001 law is pretty good, all things considered. But there are a whole lot of people who are saying we're going to lose our adequacy if we don't update our statute. And a whole lot of people said we should just simply implement the European GDPR, and that way everything will be hunky-dory. And interestingly, it's been known for some time that our adequacy was being reviewed. Our adequacy was actually renewed on the 15th of January, 2004. And many were surprised because the adequacy finding, the recent one, was obviously through the lens of the GDPR, but it was based entirely on our existing PIPEDA, so the law that originates from 2001, and other legal protections with little said about the upcoming CPPA. And there was little said about the lack of the enforcement order authority by the Privacy Commissioner. And a lot of people thought, we cannot be adequate unless our Privacy Commissioner has the same sorts of powers as a European DPA. That seems not to be the case. It certainly hasn't taken the wind out of the sails for privacy law reform, but it's taken, I guess, one argument away. And so it's an interesting case study that you can have what a lot of people call an antiquated privacy law and still be considered to be adequate. And I guess it's something significant, and it's better than nothing. And we'll continue to do that. But again, as I mentioned, it's still confined to personal information right now that's transferred into Europe in connection with commercial activity, to the exclusion of employee personal information. And I think that's a significant gap that I think needs to be fixed, that hopefully will get some attention. We've also seen at the same time significant movement in Quebec. And so Quebec decided to take the reins and be one of the first ones in Canada to do a significant overhaul of their privacy law. So they had the first private sector privacy law in Canada that regulated businesses, what they could collect, use, or disclose. That's been since the late 1990s, or middle to late 1990s. It predated PIPEDA. It was very different from PIPEDA and very different from other provincial laws that have followed. But they did some significant reforms in the past few years that I'll just touch on briefly. As is the vogue these days, it introduces significant GDPR level penalties. Although we haven't yet, all these changes are relatively new, we haven't seen any significant enforcement actions to get a sense of the interest of the regulator in imposing big penalties. There is right now a joint investigation of the Quebec regulator, by the Quebec regulator with all of the other provincial and federal counterparts, going after TikTok, for example, and going after OpenAI. And so whether this will be an opportunity for them to try to flex their muscles, not sure. The previous commissioner in Quebec had said that she intended to take more of a light approach initially in terms of providing guidance to companies to come into compliance rather than coming down on them with a big hammer. We have a new commissioner, and it's not clear whether their approach is going to be the same. So everybody's watching to see what's going to happen. When it comes to most of the people on this call, what are some of the most important things? Well, probably the most significant is that there's an obligation now in the updated Quebec statute to do a privacy impact assessment for any outbound transfers of personal information from Quebec. And so that includes personal information transferred from Quebec to Ontario, so even within Canada. But it is prohibited to transfer that information out, which also means that if you are outside of the province of Quebec and you're collecting personal information about residents of Quebec, you likely have to do a privacy impact assessment in order to determine essentially whether there will be adequate protection wherever that information lands. And so a requirement of that formality. You don't have to file that with the privacy commissioner, but I expect the privacy commissioner will be interested to read it in connection with any investigation. A significant change is opt-in is required for all tracking cookies. So any cookies or any similar technologies that are used for profiling or locating somebody's location, that has to be done on an opt-in basis. And so a lot of companies, for example, have started to use the same cookie banners in Canada that they have in Europe. And in fact, those cookie banners are not adequate because it has to be opt-in. The person has to choose to implement tracking cookies, where the default in the rest of Canada is certainly you don't even need a cookie banner in the rest of Canada, but you could do opt-out in the rest of Canada. This is opt-in for those cookies, but there's no distinction between, I talk to clients all the time and say, well, but these are necessary cookies. We have these different categories. It's like, well, it comes down to do these particular cookies fit into the category of tracking cookies for the purpose of the statute? If they do, you can't implement them unless the person has chosen to opt them in. And so significant difference from elsewhere. There's mandatory breach reporting and notification, similar to what we now have in the rest of Canada and around most of the world. And it does expressly include a right to be forgotten, so a right to be removed from search engine indexes in particular circumstances that are parallel to, but not identical to what's happening or what has happened in Europe. And so that kind of in a nutshell is what's going on in privacy law reform in Canada. So much of this, other than the Quebec legislation, is still in process and is still subject to maybe some minor changes, but I don't think we're going to see some radical changes. There is always, because of our parliamentary system, if we end up with an election. So, for example, for some reason, the current government calls an election, or there's a non-confidence vote, and we have a minority government that's being propped up by a coalition. If that falls, then everything falls off the table for the election, and they restart from zero. And whether it's very likely that we would have a conservative government after an election. At least that's what everything looks like right now. Whether they would be interested in implementing the same type of legislation, it's not clear. So I would say there's probably an 80% chance of this going through. And there's a whole lot of people who think, well, it should just be jammed through at least the privacy piece, because there's a lot of consensus that, it could be a whole lot worse. And largely people think that it's an improvement on what's existing.